So involuntary bankruptcy, creditors force debtor into bankruptcy if 12 or more creditors, you need 3 or more with unsecured claims. I guess, Kelsey, why unsecured?
Because the secured gets better treatment than
Sort of. Sydney, if you're a secured creditor, you can seize the property in a judicial proceeding, therefore you don't need to go through bankruptcy. So that's why we get priority to unsecured claims. And I think in the notes I posted originally it says if less than 12, if less than 3, it should be less than 12. So please fix that mistake so there's no record of it. So does this mean that Linda, if Donald Trump owed me $16,000, and I found 2, and I'm sure he would have more than 12 creditors. So if I found 2 more people, and collectively he owed more than $15,325, could we petition him into involuntary bankruptcy? Yes, and it seems, Brandon, that seems outrageous because to him, to us, $15,325 is money. To him, it's a tip. But then, Brandon, so the issue is, if 3 of us got together and he owed us more than this amount, we could file an involuntary bankruptcy petition against him. But then, Brandon, how would he defend himself? He would say, I'm not insolvent, and as long as he's paying his debts as they become due, then the petition would fail. Then, being the vindictive guy that he is, he would then sue us, is that right, and get monetary damages and perhaps punitive damages. So, Megan, do you advise us to proceed against the Donald?
no.
No. Okay. See, this is scenario 31-1, and tell me what the facts are. Michael, we have 3, and we have 8 creditors, I think. O owes us $30,000. S owes us $25,000, and then we have 6 others who owe us a total of $15,000, because the total debt is $70,000. You're welcome. So, answer the question. So, are those the facts? Taylor, you agree? Yes. Okay, now question number 1. Question number 1, Linda, read us the question, and then AJ answer it for us. I should have given you advance notice I would ask you this, but that's okay. And then Cindy, you can read question 2.
Okay. Under the bankruptcy code, can Burke with the $500,000 range voluntarily petition herself into bankruptcy?
One of the facts I want to ask about, Michael, in the facts of the problem, it says it has a range value of $500,000, almost all of which is exempt under state law. Michael, I'm a little bit confused. Bankruptcy law is federal or state law? The bankruptcy code is federal or state? Federal. However, states can add additional exemptions. So we have delineated the exemptions that were listed in the notes in the textbook, but states could add to that. And Katie, this guy's a farmer. Do you think farmers receive special consideration from legislative bodies? Because everybody loves a farmer. So it's probably exempt because it's farmland. But the question, AJ, is, can he file a voluntary petition in bankruptcy? And the answer is yes, as long as he's insolvent and he's unable to, or, I'm sorry, anybody could file a petition. The court may not grant relief. Question number 2. Linda, read us the question and Jody answer it.
Could either Oman or Steve force Burke into involuntary bankruptcy?
And Jody, the answer is?
Yes.
The answer is actually no. because Katie, he's a farmer, and you cannot force a farmer into bankruptcy. Again, why? Everybody loves a farmer. Now, Jody, if he was not a farmer, then the answer is, and let's go back to the rule. The answer is, he's got less than 12 creditors, and as long as one of them has a claim more than $15,325, and we'll see that O could force him into involuntary bankruptcy, and so could S, and enough of the others. Oh, the others could not do it. Why? Because their total is only 15,000. So O could do it, S could do it, the others could not do it. Except in this case, Katie, nobody can do it because he's a farmer. And everybody loves a farmer. That's true, isn't it? Aren't you married to a farmer?
Yep.
Doesn't everybody love a farmer?
Yeah.
Very good. Question number 1. Alex, this looks familiar. Well, probably because I've looked at it before. So Alex, what's the answer? A. And do you agree? Very good. Question number 2. Which of the following transfers by a debtor within 90 days of filing for bankruptcy would be set aside? Linda, to set aside means to treat it as if it did not happen. So yes, suppose, Brandon, yes, suppose that I owe my sister $5,000, and Monday I pay her $5,000, and then Wednesday I file for bankruptcy. So you're the trustee. Can you set aside my transfer to the sister?
Yeah.
Yes. What does that mean? What does that mean? That means that, will the sister be required to pay the money back to the estate? Yes. So to treat it as if it did not happen, and Brandon, you as trustee have broad powers, and therefore you can demand that the sister pay the money back, because Linda, arguably, she never should have got the money in the first place. And the reason, Megan, she never should have got the money in the first place is because that puts the other creditors at a disadvantage, because Candace, that's $5,000 less to be distributed. Okay, so that's what set aside means. So, Linda, what do you think about a gift to charity?
No.
No. What about paying a business utility bill, Brendan?
No.
That's an ordinary course of business. Borrowing money, taking out new debt. No. Therefore, I hope the answer is D. Linda, prepaying an installment loan in inventory, that looks like you've given them preferential treatment. And Taylor, why would you want to do that? I understand why I want to give preferential treatment to my sister to make the conversation at Thanksgiving dinner go smoother. Which it never does, but anyway, we have one less thing to argue about. But why would I want to give preferential treatment to these people? Am I still going to be in business with them when we're done? And I want to maintain a good relationship with them? So I might want to give them preferential treatment, not for any sort of emotional tie, but because I want their help in the future. But so the answer, Brendan, is
D.
D. Question 3. AJ. Under the Federal Bankruptcy Code, which of the following rights or powers does a trustee in bankruptcy not have? And actually, when I first read this, AJ, I misread the question. I missed the not. AJ, is that important?
Mm-hmm.
So let's see what he does have. The power to prevail against a creditor with unperfected security interest. I think so, because he steps in, Brandon, the trustee, steps into my shoes. Katie, the power to require persons holding the debtor's property at the time. So therefore, Katie, if you perfected your security interest by possession, perfected it by possession, can Brandon demand that you surrender the property? Yeah, because Brandon, if she doesn't surrender the property, you can convert it to cash. So he has that power. C, the right to use any grounds available to the debtor. So Katie, he steps into my shoes and has the same rights that I would have. So I hope, AJ, the answer is D, the right to avoid any statutory liens against the debtor's property. So the power he does not have is D. Katie, you agree?
Yes.
And then AJ, when I first read this question, it's like, gee, A, B, and C are all correct. But that's because I didn't read the question. Kelsey, is that important? Question 4. Whoops, who has question 4? Oh, Jody, question 4. On April the 1st, Roe borrowed $100,000 from Jet to pay Roe's business expenses. June the 15th, Roe gave a signed security agreement and financing statement covering Roe's inventory. That is like, I'm kind of confused here. Jody, why would they do that? We already have the loan, so then several months later, we turn a unsecured creditor into a secure creditor. Why would I want to do that? Or, why would Jet want me to do that?
Because you know you're going to file and he wants to make sure he has a claim.
And so he'll have a higher claim than, July 1st, Roe filed for bankruptcy under the Federal Bankruptcy Code. Brandon, the trustee, can set aside Jet security. Can he set aside? So let's list the rules. To set aside, you're going to have a transfer for the benefit of a creditor. Jody, do we have that?
Yep.
And again, how is the creditor, we already owe him the money. We already owe the money, but how is he better off?
He has a higher.
He has a higher priority. Number 2, if it's a prior debt, or Jody, to use legal terms, it's an antecedent debt, which means it's a debt that pre-existed the security agreement. And 3, if it's within 90 days. And is it?
Yep.
And 4, it gives creditor a higher priority, and does it? And Katie, I don't know why I want to do this. And I think, Katie, Taylor, I might want to do this because I might have future business dealings with this person because I do have a life after bankruptcy. So now that I've laid out the rules, the answer to the question, Jody, is
B.
B. Who else? Who else is with you? Gayla, you agree?
Yes.
Matthew and Bijou, question number 5. Kayla, was just going to sit there and let me ignore you?
I did not remember what was my question.
So what's going on? Oh, you're not even...
You don't have to cover. I don't have to cover page it.
Oh, that makes sense. Okay, so Matthew, under Chapter 7 of the Federal Bankruptcy Code, what effect does a bankruptcy discharge have on a judgment creditor? Brandon, I guess the first question is, what's a judgment creditor? It's somebody who I've gone to court to sue, or somebody sued me, and they either in a tort action or a breach of contract, or because I haven't paid my bills. So a judgment creditor is one that the debt exists because of a court ruling, because of a judgment. But Brandon, would a judgment creditor be treated any different from any other creditor? I mean, Kelsey, that's how the debt arose. It arose because a court ordered me to pay him. But Brandon, would that treat him or her any differently?
Yeah.
How? Any different from any other creditor? No. So he would just be in line with the other creditors. Therefore, the judgment creditor's claim is non-dischargeable. Well, surely it is, because remember, Brandon, when we talked about torts, there are two types of torts. There's an intentional tort, where I go up and hit Sydney on the head. I did that on purpose. Or two, a negligence tort. A intentional tort is not discharged in bankruptcy, but negligence would be. So I think A is wrong. The judgment creditor retains a statutory lien. Well, not after the discharge. All that goes away. C, the debtor is relieved of any personal liability. Or D, the debtor is required to pay liquidated damages. It seems like to me, Brandon, that A and D said the same thing in different words. Do A and D say the same thing in different words?
Yeah.
So I think we can discard those. Therefore, the answer must be C. The judgment creditor is discharged. The debt is discharged, looks like any other debt. But notice that's when the bankruptcy is completed. Because I think the trick here is they're trying to teach you to think in terms of a tort action, an intentional tort, and that would not be discharged in bankruptcy, because there's no indication that that's the case here. Question number 7. Sorry, question number 6. 7 we're moving on. Question number 6. Who is 6? Sydney. If you answer this question correctly, I won't hit you on the head. Therefore, you cannot sue me, and you will not become a judgment creditor, and then Brandon, my trustee, will not have to worry about you. Okay. In general, which of the following dates would be discharged under the voluntary liquidation provision? A debt due to the negligence of the debtor, that would be discharged. The intentional tort would not be. Alimony payments will not be discharged because we want to protect domestic relationships. A debt incurred more than 90 days before the filing of the bankruptcy and not disclosed in the petition, assuming that is by my own negligence, that would not be discharged. I'm sorry, assuming that is due to my negligence, that would not be discharged. And income taxes paid within 2 years. Income taxes are not discharged unless they're more than 2 years old. Therefore, Sydney, the answer is A. Who else had 6? You agree?
Yes.
Very good. So now, so Candace, my first piece of advice here is, if you look at this question and say, oh my God, where do I begin? And here's my advice. Candace, read the question first. Don't get bogged down in the data. Don't read the data and then start diagramming stuff and saying what might happen, because you might be analyzing questions that they do not ask. So ignore the data and go directly to the questions. Okay, now with that in mind, when does field security interest on the SOFR attach? And Candace, what's the answer to that question?
D.
Actually, I don't have the dates written yet.
It's March 1st.
March the 1st. Kobe, you agree?
Yeah.
Kobe, when does it attach?
March the 10th.
March the 10th. What happens on the 10th?
File the finances.
You file. Okay, so Candace, why does it attach on the 1st?
Because that's the day they were delivered.
And why is it not perfect? Well, why is it not perfected that day? isn't possession, oh no, it's possession by the creditor. And this is possession by the debtor. And so Kobe, it's
The first.
so it's attached on the 1st and it's perfected on the 15th. Okay, now, the next question. On the 10th, I'm sorry. It's attached on the 1st and perfected on the 10th. Next question is, Alex, when did the security interest in Mo's inventory attach?
February 1st.
What happened on February the 1st?
They created a security agreement.
Security agreement for both after, present and future inventory. And if you think about that, Alex, it's suppose that I'm regularly buying inventory from this one source, and I've got 10 different shipments in my warehouse, some of which came in February, some of which came in March, some of which came in May, some of which came in June. It would be impossible to determine which widgets came first.
Yeah.
Therefore, we can't go by the possession date. Therefore, we will go by the agreement date. So therefore, that's attached on January the 2nd. Jody, when is that security interest perfected?
On March 5th.
And what happens on March the 5th?
That is when he filed the financing statement.
Oh, very good. So question number 5. Greg, who has priority between Field and Felton's?
Fountain.
Because
They filed the financing statement.
his was perfected first. So the answer there is B. AJ, tell me who Runsford is. He's a customer who buys the property in the ordinary course of business. So AJ, if you went to King's Appliance downtown and bought a refrigerator, you should not have to check and see if there's a security interest in that. Because Kelsey, if she did, then that would impede commercial activity, and we don't like that. Now, one thing that I'm a little bit worried about, the fact that he had notice. AJ, does that matter?
No.
No, it does not matter. It would matter in, Kelsey, with negotiable paper, whether you hold or due course, but it does not matter with secured transactions, and we give him preference over everybody. Therefore, AJ, the answer to number 6 is C. Very good. So reading the questions first, I want to know, questions 7 through 11 asked us, Michael, when a trustee can set the contract aside. So Michael, the payment is to Gene, who is that person? Is the brother of a director? Does that look like an inside deal? And let's suppose we didn't know that this was a brother of a director. I think, Michael, that would be possible. But remember that in audit, for example, auditors have to maintain independence in fact as well, in appearance as well as fact. And saying this looks bad, whether we have any bad motive or not, so can we set this aside, Michael? Yes. Which means, Brandon, we can force them to pay the money back to the bankruptcy estate. Brandon, what about 8? The donation to a charity?
No.
No, so that's okay. In fact, we want to even encourage that. Tellini, the security trim agreement to every finance company should be set aside. So help me out with this one, Sydney. I'm waiting to see. Can it be set aside?
Yes.
Why?
Well,
Because
no.
I don't think that's the issue. Now I've got it on the screen. Further refers 2014, Sparrow gave Everett Finance Company a security agreement covering Sparrow's security office supplies to secure a loan previously made. So Sydney, is this similar to the other question that we did, where we take an unsecured creditor and we make it a secured creditor? So is that a preference item that can be set aside? Notice, not because it's a secured interest, but because it's a secured interest of an antecedent debt, a prior debt. So again, Linda, what we're doing is we're taking an unsecured creditor and making them a secured creditor. And Taylor, the reason the law doesn't like me to do that is that gives him preference over others, other secured creditors. And Kobe, if you were one of the other secured creditors, you would say unfair. So yes, it can be set aside. Okay, now, question number 10. Megan, the payment to the appliance company should be set aside. Do you see any insider deal here?
No.
Do you see any elevation of creditor?
No.
It seems like this is just a normal cost of doing business, so yes or no?
No.
Michael, what about the purchase from Hugh Company should be set aside as preferential transfer? Anything not appropriate here? So no. So the only ones, Michael, that could be set aside is 7, because that's an inside deal, and number 9, and Cindy, what happened in, I'm sorry, Tellini, what happened in number 9?
You changed it unsecured creditor.
Very good. You promoted an unsecured creditor into a secured creditor, therefore giving him better treatment. So Kelsey and Tellini helped me with this. And tell me, I'm sorry? Yes.
Does it matter on the date with like number 9, since like we gave the security agreement on February 1st and they filed for bankruptcy on?
No, because date only matters if there's some indication. The 90-day rule is only one of the rules. So it's not the only rule.
So it doesn't matter that they gave the security agreement before?
It doesn't matter. It would matter if it was a related party, if it was elevation of the security interest. Okay, so let's take this case. Tellini, let's take the case where in 2005, you loaned me money in 2005. In 2006, you're nervous about me paying you, and so I upgrade you to a secured creditor, and then in 2015, I file bankruptcy. That would be the elevation of a unsecured to a secured, but that is way before the 90-day period. So 90 days is in and of itself is not enough. Other questions? So let's go through here. Kelsey, tell me who these people are. These are administrative fees. And the non-parallel office supply, office cleaners are,
Just a service for the ordinary.
so it's unsecured.
Yeah. And there's unpaid wages for Elizabeth.
And then the third bank is a secured creditor,
The IRS's taxes within 2 years,
tax guys. And then Elizabeth is a
unpaid wage.
employee. Now that I know who these people are, and Candace, would it make sense to do this sort of analysis before you start answering? That is to identify who's who. Now that I know that, I think that Tellini, I can now say who's first. Who's first?
Third bank.
Third bank. So they're number 1 because they are secured creditors. Who's number 2?
Bankruptcy offenses.
Brandon is paid second because he's an administrative cost. Third would be
Elizabeth
Elizabeth, because she's an employee. 4th would be,
The IRS.
Yeah, the 3 is just one line down. The 1's fine. The 3 goes.
what's fine,
3 should go
oh, I'm sorry. And then 4 would be the IRS. And then if there's anything left, which is probably not the case, the office cleaners. So what should they have done? Getting their security or just not clean the office? Okay, now that I've done that, I now think I can go through and tell you who would get what. And Kobe, help me with this. And so the question is that Spider, so tell me about Spider. We owe 15,000. Is
Yeah,
that right?
yeah, there's secured creditor 50,000.
And so, and we sold the property. We sold the property that was secured, and we got $12,000 from that. Which means that there is 3,000 left. Now, therefore, 12,000 is secured, 3,000 is unsecured. And the problem tells me, Kobe, that unsecured creditors get 50 cents on the dollar. Therefore, Spider is going to get 12,000 plus half of 3,000. Therefore, Spider will get 13,500. Kobe, do you agree?
Yeah.
And Cindy, I think we did a problem last time. I think Cindy, I owed you 10,000, and you seized, and Brandon, the bankruptcy trustee, seized my property. You owe me 10, and he sold my property for 7. So that means that you get the 7, plus you would go to the bottom of the list with the other unsecured creditors. Now, Brandon, in that same case, well, I owe 10, you seized the property and sold it for 13, Cindy gets the 10, and then the 3 would be added to the bankruptcy estate and spread accordingly. So I think, Kelsey, having done that, I think Elton becomes the same thing, isn't it? And how much did we owe Elt? $30,000. And we took the asset and we sold it for $25,000. Therefore, we still owe $5,000. Therefore, Elt is a secured creditor in the amount of 25, unsecured creditor in the amount of 5. And the problem tells us that we'll get paid 50 cents on the dollar. Therefore, Elt will get 25 plus half of 5,000. So Elt will get 27.5. Now, Linda, Light and Power Company is unsecured. Therefore, they will be treated as any other unsecured creditor, and we owe them 600. And the prompt tells us that we're paying 50 cents on the dollar. Therefore, they will get 300. And then the office supplies, we owe them 2,000. And Linda, they will get 1,000. So Candace, I think when one first looks at a page-long scenario, one would tend to panic. But if you simply read the questions first, and then go back to the data and dig out the information needed to answer that question, it makes it very manageable. Next question. So Kayla, we have a Flossdale Corporation was petitioned involuntary bankruptcy under liquidation provisions of Chapter 7 of the Federal Bankruptcy Code. We contested the petition, DART has not been paying its debts as they become due, as defaulted on mortgage payments. So the first question, Kayla, is, let's go through. The bank is a secured creditor. Kelly, you agree?
Yes.
And then the IRS is the IRS. JOG is unsecured. And it owes us, we owe them $3,000. The electric company is unsecured. And we owe them $1,200. And then Decoy has a claim of $19,000, of which $2,000 is secured, and therefore $17,000 is unsecured. So secured is $2,000, unsecured is $17,000. So Kayla, the question is, who can file the petition for involuntary bankruptcy? Is it 1, 2, and 3? Is it 2 and 3? Or is it 1 and 2? Or is it 3 only? Is it John, Nanstar, or Decoy? Decoy. Because their debt is the only one that's more than 15, the magic number. And we have less than 12 secured creditors. Okay. Who's the other person on this one? Oh, do you agree?
Yes.
Very good. I've got Carolyn written down. Who's Carolyn? Okay, question 22. Which of the following statements would correctly describe the result? So Brandon, DART is the debtor win because the petition should have been filed under Chapter 11. Well, that's wrong. 2, DART will win because there are not more than 12 creditors. Well, that's wrong. C, DART will lose because it's not paying its debts as they become due. D, will lose because of its debt to the IRS. Well, that's irrelevant. So therefore, the answer must be C. And the problem tells us that they're not paying their debts as they become due. That's the definition of insolvency. Therefore, DART against its will go into bankruptcy, which Jody's one we call it involuntary. Okay, now, Greg, Kelsey, you agree?
Mm-hmm.
Question 23. Taylor, which of the following events will follow the filing of the Chapter 7 involuntary petition? Will a trustee be appointed, Taylor?
Yes.
Greg, will a stay against creditor collection proceedings go into effect?
Yeah.
Therefore, Greg, the answer is
A.
A. Both are true. So now, Taylor and Kelsey, help me determine how much they're going to get. And Kelsey, tell me about this guy.
Manstar has an unsecured claim, so he'll be last to get.
Also, did he not file late?
Oh, yeah.
So not filed on time. And that is their fault,
Yes.
therefore they're out of luck.
Yeah.
Now, then, tell me about Franco,
They are secured.
and tell me about the IRS.
They're the IRS.
Okay, therefore, Nanstar will get nothing. Taylor, you agree?
Yes.
The IRS will get $12,000. Now let's see what the bank gets. For that, I need some room, so let me turn the lights on. And let me turn the projector off. So, Angela, get this computation on the side. So, Kelsey, the problem tells me we have cash of 100,000. Now the bank, we owed the bank 75, but the property that we took that the bank had security interest in was sold for 70. So secured bank, 70,000. And then the other property that we had a security interest in was sold for second creditor, was sold for 2,000. So help me with the math here. Kelsey, 100 minus 70 minus 2 gives me 28.
28, yep.
And then Taylor, the IRS, will get 12,000, which means left to allocate 16,000. Now, let's go back through the data and tell me who do we owe the money to, because I'm afraid we don't have enough money to pay everybody. So, Kelsey, how much do I still owe the bank? 5. How much do I owe Jog?
3.
How much do I owe Decoy?
9.
I owe them 19, but I paid them 2,
So 17.
which means I owe them 17. Now, Taylor, help me with the math. 5 plus 3, Kelsey's a tax person, so she can't do math in her head. So 5 plus 3 plus 17 is 25,000. So Brandon, you're the trustee, here's my dilemma. I've got $25,000, I've got $25,000 of claims to pay, and I only have $16,000 of cash. So, tell me, how much am I going to pay the bank? 16 over 25? 16 or the available cash over the claims to be paid, and we owe the bank 5,000. So when I do the math, I'll get 3,200. But Kelsey, I already owe, and I've already allocated 70 to the bank. Therefore, the bank will get
73,200.
73,200. Kayla, you agree?
Yes.
Because they'll get 70,000 in round 1, and then they'll get 16 over 25 of the remaining asset. Now, Kelsey, the question does not ask you what does Job get, but Job would get 3,000 times 68%, 16 over 25. Yes, ma'am.
In the 25,000, do we not include Nanstar because it wasn't filed timely?
Yes.
Even
Therefore, yeah. Therefore, Nanstar, because they were not filed on a timely basis, they get nothing. Because they were, Brandon, and when you took over as a trustee, you filed timely notice to all the creditors, and this one did not file a timely claim. And Megan, at some point, Brandon is going to have to have a cutoff date. That is, we can't wait years for a creditor to come forward. So all the creditors were given notice, and they just did not file promptly, so they get nothing. Questions? Very good. See you on Friday.
Do we have to do calculations?
Potentially, although I would not worry about, for example, all the precise numbers. But in this case, I think you could have done this problem without knowing.
Like,
Yeah. That, all you need to know is